Good afternoon. I am Manhattan District Attorney Cyrus Vance. I have brief remarks about today's developments, but I will not be taking questions afterward. Today, my office filed an indictment against defendant Dominique Strauss Kahn following allegations of a sexual assault in a Manhattan hotel. This case began with the prompt reporting of the attack by the victim to members of the hotel staff and then to the New York City Police Department. Supporting evidence has been collected by both the NYPD and the Manhattan District Attorney's Office. Yesterday, a grand jury, which is an independent body under American law that is comprised of impartial citizen jurors, considered the evidence presented by my office. Under American law, these are extremely serious charges, based on the grand jury's determination that the evidence supports the commission of non-consensual, forced sexual acts. The defendant was indicted on all of the charges presented to the grand jury, including criminal sexual act in the first degree, a Class B violent felony, and attempted rape in the first degree, a Class C violent felony. During the course of this criminal process, this defendant, under the supervision of an independent and experienced judge, will receive all of the protections available in our justice system to ensure a fair trial. These protections are guaranteed to everyone charged with crimes in these courts, whether or not they are residents or visitors. And that includes each of the more than 100,000 defendants who come before my office each year. Fairness and impartiality in our American criminal justice system has been the bedrock of our democracy for more than 200 years. It has been rigorously upheld by New York courts and by our office. The work of the Manhattan District Attorney's Office will be guided in this case, as it is in every case, by one principle: to do what is right without fear or favor, wherever it leads. Thank you.
Without proof. It is simply an assumption with no basis in fact. The factual truth is that he is exactly what he said he is, and that until Saturday he had been engaged back and forth from the United States to foreign countries with on the business of the IMF. And I suppose one can always imagine situations in which people become highly visible fugitives from sex offense charges, but frankly that is fundamentally unrealistic, and in this case really an unprovable and not a very weighty argument, if the court please. We have I think one final thing in terms of the hasty exit. He checked out of his hotel at 12:25, joined his family member in a midtown restaurant at 12:45 roughly, and was there in plain view of the entire world until about 2:15, hardly consistent with a man trying to hide himself in the city of New York. Thank you, Your Honor. Would you like to address Mr. Valenti and ask questions about?
Well, I wanted to read what was submitted here. As I understand it, the people, at least in the past, have indicated no problem with the integrity of the company, although they certainly have not agreed that it be employed in this case. As I understand it, and please correct me if I have
in the home, whether it's monitoring for escorts to and from the courthouse or to counsel visits, I think it's important that the security company, Strauss Friedberg, be the ones who determine what is necessary and how many guards are necessary, rather than a number that's set in an order of the court. There's also a stipulation in the order that references weekly religious services that would require him to leave the home. We have no details on that whatsoever. We don't know when those occur. We don't know where those are, and how the transportation to and from there. And that's a legitimate security concern, both for the people and for the monitoring company. Visitor restrictions wasn't something that was brought up by counsel, and it wasn't something that was addressed by the court. It's our proposal that if Your Honor is going to release the defendant under any conditions, that his visitation be limited to one visitor other than counsel and immediate family members. Again, just as an overarching condition, we want the security company to be the ones who make the determination on what's appropriate.
So we'd ask them to, that, as well as the reporting aspect of this, and I agree that this should be whatever is necessary in the professional opinion of the security company to ensure that they can do the job that they are expected to do.
And Your Honor, in that light, they have provided us, and I'm sure defense has seen this, a copy of their provisions and protocols that they would normally be in place.
When I said it should be incorporated by reference into this.
This is a different document, Judge. That is the proposed agreement that they made to defense counsel. This is what their
protocols.
Standard protocol is. And
Attached to the
well, in any event, I'd like to hand this up to the court.
This is what I have, the same thing. And I did mean to include also that, and we'll talk about visitors in a moment, that the company will be directed to provide information as needed by the people in terms of the defendant's comings and goings and visitors as the people require, with a copy to the court. But I do agree that the security personnel should be whatever the company deems necessary to fulfill its obligations, that the people should have notice of any travels by the defendant and of visitors to the defendant, and a copy of whatever notice the people require can be provided to the court. As far as the number of visitors, the protocols that I had reflected a limitation of 4 visitors at one time in addition to family members. Is there something, Mr. Taylor, you want to say about that?
Well, Your Honor, I don't think there's any reason to why a greater number of visitors rather than a lesser would make any difference. If it does to the security company, we can deal with it. There are friends in New York who will want to visit Mr. Strauss Kahn. There are other, there's not much family. There are only 2 here. There may be others who come. So 4 is not a very large number. It's, you know, four people for dinner.
Assuming that is not something that the company thinks is inappropriate, I will leave it to their discretion within the protocols that I have.
Well, Judge, that would be one visitor other than counsel and family members was a recommendation that the company just made to us when we were speaking with them.
This is something new to me. Counsel, are you aware of that? Are you aware of the company's concern about?
I spoke to Mr. Valenti yesterday, and we discussed this. He said he thought 4 would be acceptable.
If the company feels that is acceptable, I will not provide a specific number of visitors. The point of this is to get Mr. Strauss Kahn to court, and unless there is some reason why having more than one visitor poses a risk to that, I will leave it as is stated in the protocol. If there is any question about this, I will be happy to talk to counsel again, with or without Mr. Valenti, if that's necessary. But at this point, I am going to direct that counsel provide the court with a new proposed order incorporating what has been said here. We'll order the minutes as well so that you can be clear as to what was said, and it should incorporate the protocols by reference or directly and the other matters that the court raised. As far as the case itself is concerned, oh, well, there was one other thing, because Mr. McConnell mentioned again about the defendant's assets. Is there something else, Mr. Taylor, you want to say about that? I think I will leave that as it is. I recognize that the defendant's wife has extensive assets. It's one reason why I'm requiring the bond, so that there'll be some additional assurance. I realize, as I said before, that money alone is not going to be sufficient to give us the assurance that we need to have. It is primarily these other conditions that I am expecting will simply make it impossible for the defendant to leave, which is really what I am concerned with.
On the issue of money, then, Judge, just one other detail. The company has informed us that they require payment in advance. If for whatever reason the defendant or whoever is paying for this service doesn't pay, we should have in the proposed order that they contact the people in the court immediately.
The company should advise all of us if there is any problem with them continuing with the responsibilities they have under this order, and they, of course, are expected to continue with their responsibilities until the court has had an opportunity to reconsider the entire securing order. As far as the case itself is concerned, I understand that an indictment has been filed and the defendant will have to be arraigned on that indictment. There is, I don't believe, any need for him to appear in Part F tomorrow morning just to have the case adjourned, so we should set a date for arraignment on the indictment in this part. And I don't know if you've discussed anything about schedule. Perhaps you can tell me what would work for you other than a Thursday.
Give me one sec, okay?
I heard you say that. All right, then, unless we change the date for some reason, the case is adjourned for arraignment on the indictment to the morning of June 6th at 9:30 in the morning. As far as the mechanics of any of this, if we need to resolve that, I'll be happy, or my staff will be happy. This is not all my staff, by the way. My staff will be happy to meet with you to work out the mechanics of that.
So, Your Honor, we owe you a revised order.
Please.
And that's...
And a bail bond?
And a bail bond. My sense is that we are not going to be able to get all that done by close of business this afternoon. It's full.
You're right, especially with the court's timelines.
On-
I'll be here tomorrow.
But could we bring him up tomorrow so that he could be released? We could have it all done tomorrow.
We can have the defendant produced here tomorrow.
Then we can get it all done at this court.
We can do that.
I'd be very grateful. Thank you.
All right, then please, the case will be adjourned, or the application is adjourned. Have the defendant produced tomorrow in this court.
And Judge, just for the record, I have served a copy of the indictment on the defense in addition to filing.
All right, for the moment, the remand is continued until the order has been signed. Thank you.
File was part of the application.